State's controversial anti-bullying bill. It is now law, and it requires schools to track and investigate bullying situations and give more training on how to prevent it in the first place. But what does all of this really mean for students? Joining us now is attorney Christa Groshek. We want to thank you for being with us this morning. Let's talk about this bill, because this is something that we've heard a lot about, and we went from having a 37-word law on bullying to having now something that is 14 pages long and is very expansive. And you read through this. Kind of give me your take on this as far as an attorney's perspective goes.
Well, this is a very broad statute.
Yeah.
Not only is the conduct very broad and vaguely defined, from intimidating, threatening, or abusive or harming conduct that's objectively offensive, but what this statute also does is it creates new classes, new protected classes, not just race, ethnicity, color, creed, sex, age, but now we've got physical appearance, marital status, socioeconomic status, academic status. All of those new protected classes are students who could claim they've been bullied, and that will require action from the school. It could also spark these students and their parents to pursue litigation.
Does this, in your opinion, open up a can of worms here?
I think so. You know, it's clear from the introduction to this statute that it was well-intentioned, that people want to stop bullying, that we want children...
Something had to be done.
That's right, to go to school and learn without interference. And there are cases where we know that children have been bullied to the point where they've committed suicide, and they've reached out to school officials, they've sought help, and they didn't get it. Those cases are the extreme. I think what we have here is a policy that's well-meaning, but it puts students in a situation where they really are checking their First Amendment rights at the schoolhouse door, and they're prohibited potentially from almost saying anything negative to anybody about anything, because everybody's in a protected class, ostensibly, according to this statute.
So what happens? I mean, if you're a parent of a child that's been bullied, a big complaint with this is that parents aren't necessarily notified of this at the school level.
Right.
The school doesn't have to notify them, but you're saying that there are ways for parents to find this out.
Right. As this bill was being drafted, there was a provision at one point where there was a presumption where parents would get the information, and it was only if they determined it wasn't in the student's best interest for the parent to be informed that wouldn't be presented to the parents. That provision was trashed, and what we have now is a provision that says parents can get information about the incident, the fact that it occurred. If they want to get more information about the investigation or the findings, they have to go through several processes to get the information that's data privacy protected. So parents and students have to jump through hoops. The problem I see with that is that once they jump through those hoops, there could have been a finding that's already been made.
Yeah, how do they fight it? That's
right, that your child has been an aggressor. Your child is a bully. Now, that's in their records. There's nothing in this statute that talks about how a student fights that. How do they get that off their record? How do they contest it? What are their rights? Who's the decision-making body?
Well, because the records are open, as you were mentioning, to colleges, too. So how does that impact a student down the line as they apply for college? Christa, we're out of time, but you have great information. We thank you. There's a lot of discussion we could have about this, so I appreciate your insight in coming in this morning.
Thank you.
You bet. Chris?